and welcome to this webinar with Pragma Lawyers. This is the latest in our Legally Speaking series where we discuss topical issues in commercial law. My name is Mark Beyer. I'm Senior Editor at Business News, joined today by McDonald, Founder and Managing Director of Pragma, and Senior Associate Nick Malone. Welcome.
Thank you.
Thanks for having us.
Good to have you. Today's topic is strategies for maximising success in dispute resolution. A nice big topic, but we've got about 30 minutes and you've conveniently broken it down into 5 different areas to keep it manageable.
Yes, got to talk about just some high level topics and then rather than delving too much into the detail.
Okay, well look, let's kick off with the first of those 5 areas, and that's the theme of pre-litigation. So Aaron, let's...
So in this COVID world, Mark, litigation's gone, it's got busier. People are pursuing each other in the courts more often than not. As you know, as WA Business News has found, every time I read your afternoon alerts, there's new legal proceedings being commenced. But the best practice, if you are a party that's finding themselves in some form of commercial dispute, the most important thing to bear in mind is that you're in a situation you probably already want to avoid. And so something that you need to consider before commencing a legal proceeding, if you're the plaintiff, or being served with a writ when you're the defendant, is whether or not you can do anything to try and avoid that occurring. Because once you get on commencing a legal proceeding, it's a bit like being the hamster on the wheel, in that it's hard to get off once you're on. So if you're going to get on, make sure that you're very confident that that is the best outcome for you. My experience is, and what all these strategies are designed to do, is to try and resolve disputes or get them determined as quickly as possible. Because coming back to that point about it, you're in a situation, you're trying to make the best of a bad situation. It's about just trying to make the best and get out of there as soon as possible. Because the most important things to people involved in these sort of circumstances are the time. Litigation's time costly, it takes people away from their core business. You've got directors who are trying to run companies who are having to deal with lawyers' emails. Money, lawyers aren't cheap, they're expensive, and usually they charge on a time costing basis, so the longer it goes, the more expensive it gets. And also the reputational risk. WA Business News reporting about, what you're in the courts, and that's less than ideal for business. So that's sort of a bit of a high level. One point I would say about litigation is there's a lot of law firms that are specialists in dispute resolution or litigation. And that term specialist, lawyers aren't allowed to use that term unless you engage in that type of work to a sufficient degree. I would encourage, it's a bit like going to the GP. You don't go to the GP to see to see them about a rare medical condition. You want to go to a specialist doctor about that particular issue, and that's the same with engaging a lawyer.
Okay. And Nick, can you give us sort of some of the details then about drilling down on steps to take before litigation?
Yeah, for sure. Thanks, Mark. As Aaron was saying, one of the things that parties don't typically keep in mind is once you're in the legal proceeding, you're on that wheel. So what are the things you can do before you even get there? The first one is send a letter of demand, or instruct your lawyer to send a letter of demand. See whether the other party is aware that you believe the debt is outstanding, if it is a monetary sum, and see if they'll repay it. That's a good step we take no matter what, to ensure that the other side is aware that we're essentially coming for them on behalf of a client and try and get them to pay up before the proceeding is commenced. But another really important tactic can be holding a without prejudice settlement conference. Now there's a lot of words there, but what that really means is get the decision makers in the same room, allow them to talk about the matters in dispute in a confidential way and in a way that the parties can't use the information that's given to them against the other side at a later date, and see if that can resolve the matter. And that can be really highly effective as a way of getting there. One other matter we might just raise at this point is, to Aaron's point about seeking out a specialist, you may go to a lawyer who says, well, let's commence the proceeding tomorrow. And one thing that you've got to ask them is there anything precluding us from doing that? Because typically there is in contractual claims. Contracts have clauses in them that are dispute resolution focused. So if you're going to bring a contractual claim to a lawyer, make sure you've got the contract so that your lawyer can analyse whether there are any steps you need to take before the claim can be commenced. Because if you go off and commence a claim and there's a mediation or arbitration clause, you're likely to find the other side will raise that with you. And if you don't concede the point, the court will stay the proceeding until that process has been resolved.
Which is a costly and pretty drastic and terrible outcome for the punter who's spent all this money on engaging a lawyer if that happens. The other thing we do a lot of is when we send a letter of demand. So say WA Business News is sending out a letter of demand for one of their clients, which I'm sure would never happen, not paying advertising fees or something like that. We would send the letter, be very matter of fact about it, but then enclose with that letter a draft writ of summons saying, we're heading down to court, we're going to file this if you don't actually pay up. And that we find that actually increases the rate at which people comply with the demand rather than just ignoring the letter or putting it in the bin. So those are the sorts of things to bear in mind. One other thing to bear in mind whenever you're commencing litigation is, from a lawyer's perspective at least, is the client's appetite to be involved in a form of dispute resolution or litigation. Often the case is you see clients come into your boardroom and say, it's the principle of the matter, or, we've got to take this on. And then you've got to sort of tease that out a bit as to how much it's going to be the principle once they've incurred $100,000 in legal fees, or how much it's going to be about just trying to get a result done. And so every person is different, and some entities and some persons have high risk thresholds, whereas others have low ones, and others are concerned about cost and time and reputation, whereas others are not. It's horses for courses, and you've got to make sure that you're picking a lawyer and a strategy which fits in with your personal circumstances.
On that theme, I reported a case recently where a very successful mid-tier contractor in WA, privately held company, had won a big contract about 10 years ago on one of the big mining projects. There were cost overruns, there was a dispute with the principal, they got taken to court. Now, the owner of that contracting business ended up being criticised by the judge because he had too much passion in the matter and hadn't stepped back and made a rational assessment.
Yeah, that's often the case. I mean, you should never be looking at these. I often give the advice to clients, never look at a commercial dispute. I emphasise commercial dispute emotively, which is a lot easier said than done. You've dedicated all your time and effort into actually entering into this agreement and tendering for this project, and then something happens and you feel like you've been hard done by. But if you look at it coldly and objectively through the prism of how much time is this going to consume for me, how much is it going to cost, those sorts of things, and what is the best rational outcome, and then unemotively, that will almost always give you the best possible outcome. And the courts are so keen to encourage parties to resolve their own disputes, which we'll come to in a moment. I mean, statistically, 2% of punters who go to court actually have their day in court. And when you tell people that statistic, they can't believe it. They think, what do you mean? Surely it's more like 50%. Like, no, actually, by the time you actually get there, you've actually resolved it, or something's happened and it's actually dissipated. So that's something to bear in mind.
And just picking up that point, Mark, just in relation to that sort of reputational issue that can arise, these are some things that clients should really keep in mind before they go off and commence the proceeding, which is you might feel wronged, as Aaron was saying, you might feel aggrieved, but have you actually thought through the time cost that's actually going to cost you and your business if you are part of a business being involved in this dispute? If it's reliant upon what someone said to someone else or what groups of people said to other people, acknowledging that all those people are going to be relevant to the dispute is really important, because you've got to consider, well, if all of those people have to be off work for a significant period of time doing their core business, what's that going to look like for our business?
Yeah.
And what cost is that going to come to?
We were involved in a dispute recently in the federal court where we were just chewing up so much of the CFO's time, digging out old emails, trying to get reports. You could tell he was getting frustrated with it all. And there was nothing we could do about it. We had to have this information, but you could just see his primary role was actually focusing on making sure that the business was operating profitably. And all of a sudden, he's just dealing with lawyers all the time. And so it's people underweigh that cost on their business, that you're away from what you're there to do.
So have we covered off that first theme then? So I think we'll move on to mediation then. So that's obviously a term we hear a lot more about these days as an alternative to going to trial.
Bloody oath. So mediation is huge for what we do. We do it all the time, regularly, because it's so successful. And the courts, particularly in recent times, are so keen to encourage the parties to do it, because you can design an outcome to a dispute that you wouldn't actually get in by going to court, because it's a binary outcome. So you can see from that slide that there's so many cases that actually don't, the percent finalised by trial on the bottom slide, 1.8%, 1.2%, it's decreasing because people are so keen to mediate the outcome. But the truth about mediation is almost, I'd say, 4 times out of 5, it's all disputes, 4 times out of 5 disputes are ripe to be mediated almost at the very beginning. Once the lawyers have exchanged a couple of letters and everybody knows their viewpoint, it's important to get the decision makers, as Nick said, in the room with their lawyers and try and come to a settlement. And the big bonus of doing that early is you haven't burnt tens of thousands of dollars in legal fees. So you can do it in a way where you're factoring that in, whereas, rather than doing it 2 years down the track. And admittedly, it's all easier said than done, but even when you go to the mediations here in the Supreme Court and you don't resolve it, as a lawyer, when you walk out of the Supreme Court, I find that I think to myself, well, we haven't done a deal today, but we've got closer, and I know what I need to do in order to convince the other side that we can do a deal, or what I need to convince my client of. And so it's the former Chief Justice used to say it's a process and not an event. So you shouldn't just view it as something that happens on one day and then ends on that day. It's something that you might have to chip away at. I've just resolved a dispute recently where we've had about 3 mediations back to back, each time getting closer and closer and closer. And we've now reached this settlement, plus numerous phone calls with the mediator and lawyers all over the place, all across the country, trying to resolve this dispute. It wasn't easy, but it's certainly the best outcome for the parties. And it's taken quite a lot of time to get there. And it's also the most cost-effective way of dealing with it. So the courts absolutely love it, particularly in what's happening a lot more now with estate litigation. So people are passing on and they're finding in their wills that they haven't been left, beneficiaries haven't been left as much as they thought from mum or dad, and it might spur on some form of litigation. And there is scope to litigate those sorts of disputes. The court is so keen to get brothers and sisters in a mediation room together to settle it, rather than put on affidavits about who loved who more, because once you do that, the dispute becomes intractable and you can't actually resolve it after that. So the early intervention is certainly the best.
Yeah, look, I regularly scan the court rulings and I'm horrified when I see the number of disputes among families over a will, and also horrified by, we're not always talking big amounts of money here. And that money could very quickly get chewed up.
There was a case not so long ago over at a estate, it was only a few years ago, where I think the value of the estate was $200,000 or $300,000, and each party had spent that in legal fees. And you're arguing over an amount that's less than what you spent on legal fees. That's what the court refers to as proportionality. The resources that you're putting into running this dispute is actually far greater than what's at stake. And the judge was very disappointed with the parties and the lawyers involved in that case.
So I think the next slide shows some of the steps that parties should take before they go into mediation.
Yeah,
perhaps
absolutely.
you could run through some of that detail.
Yeah, thanks, Mark. So some of the things for parties to consider before getting to mediation is there anything preventing us from doing the deal on the day if we were to hold a mediation, if I can put it that way? One of the things is, well, do we actually need to know what the other side says about the claim that we're bringing? Are pleadings required? Do we need a statement of claim and a statement of defence? As Aaron was saying, a lot of the time you don't. Parties know what each other think of a matter, that they're aware of what the other party says, because the parties themselves have probably been involved in meetings with each other, or phone calls, typically highly emotional phone calls, going back and forth. Then they've had a lawyer intervene and the lawyer sent a letter. That lawyer's received a letter back. So the parties are fully aware of what they say is the state of affairs. So do they need to incur the costs of their lawyer drafting a pleading or not? There are cases where the parties may understand what each other says from a factual perspective, but there's a technical legal argument that's going to be raised or foreshadowed, and they may need that to be pleaded before they can respond to it and get into a mediation room. So as a client, I'd certainly be asking your lawyer, do we need pleadings? Is that something that's actually required at this juncture, or can we just get to a mediation now? Another part of that is really, well, do we require any information that we don't currently have? That's the big one. And if hopefully most who are on this call don't get involved in legal proceedings, but for those who do, if you're the decision maker who will be in that mediation room once we get to that stage, tell your lawyer if there's anything you need to get yourself in the mindset of settling the matter. So if one party says X and the other party says Y, and in saying Y, that party relies on 3 documents, and party A doesn't have those documents, it's going to be very difficult to convince party A that that set of affairs is the true set of affairs.
So to put what Nick's saying in another way there, Mark, is mediations never work when one party feels ambushed at the mediation with new information. It's really important that there's an exchange, an open exchange of key documents or contracts or purchase orders or whatever it is that supports one's case. And they can be exchanged on a without prejudice basis so that they can't be used later on in the court proceeding. But I've been involved in mediations before where the lawyer's rolled up and he's got a 10-page position paper and we all sit down and he hands it and he expects you to read it there and then. Always a huge no-no and a massive mistake, and it never helps. The clients feel ambushed and the whole thing's you've got to start again and come back in a month's time. So it's about making sure that everybody's ready to go to mediation and the case is ripe for it, which as I say is more likely than not. It's something that we do with our clients is actually walk them through the advantages and disadvantages of mediation, which is what we call a WATNA and a BATNA, where showing clients what's the worst alternative to a negotiated resolution and what's the best alternative and what's the most likely outcome. When clients realise that what they stand to lose, because when you lose a legal case, you've got to pay the legal fees associated with doing that, then it actually crystallises in their mind that they should try and settle it. So on that there, you can say it's really helpful for a client who's about to go into a mediation to understand this, and this is just something that we've just knocked up as a bit of a hypothetical, but the best outcome, before going into a mediation, you can say, listen, the best outcome is that we win in your case, they have to pay your legal fees, and you're going to come out with that number at the top right-hand corner. But the worst outcome is that we lose the case, you don't recover anything, and not only have you got to pay your own legal costs, but you've got to pay the other side's legal costs, and then you get that number on the second row, and there's a huge disparity between the two. And obviously it's the lawyer's role to advise on what the merits of the case are, what is the likely outcome, what your strengths are, what your weaknesses are, because litigation is so inherently uncertain. I mean, there's no way that a lawyer can tell somebody on even the strongest case that it's a guaranteed winner. I don't think any lawyer's ever prepared to say that, unfortunately, because it all depends upon how people might give evidence on the day and credibility findings. And so if you take into account all the things that you can control and say, this number might be a good negotiated outcome, which is a number in between what the best possible outcome is and what the worst possible outcome is, and something that you can live with. The mediators at the Supreme Court have a saying that a good settlement's where both parties walk away disappointed. And there's so much truth to that, because everybody walks away saying, oh, I could have got a bit more, and the other one walks away saying, oh, I've given away too much. And the truth is, it's the best result for everybody when that happens.
That you get the deal done.
And
people can walk away. That's the crucial bit. Okay. And then I guess the next theme we wanted to talk about is discovery, which is can be an excruciating process.
Yes.
So tell us a bit more about that.
Yeah, it can be terribly hard on the clients and the lawyers, frankly, and on the clients for 2 reasons. One, they have to go through all their records to find the relevant documents and provide them to their lawyer, which can take them an enormous amount of time and effort. And then equally, the lawyers go through it all and can spend quite a bit of money putting it all into a nice list that the court requires it to be in the right order. And what the courts have developed over time is these rules around, well, how are parties supposed to give discovery, and what does the court expect when parties give discovery? And where the courts have landed now is that what used to be called general discovery orders are rarely made. And the reason for that is that cost element. It just costs so much for parties typically to go through the discovery stage. So what's in vogue at the moment is discovery by categories. So that is where the parties themselves select the certain categories that they think each party should give discovery of, and then only those categories is discovery provided for.
It's just discovery is one of those classical areas of the law where it's incredibly expensive from a dollar's term for the clients, because you effectively got lawyers. I mean, in the mega litigation, I've been involved in cases where there's 45 lawyers all working on the one discovery, where they're all just enumerating documents, and now there's technologies and stuff which make it far more cost efficient, but it's still an expensive process. And the truth of the matter is, parties might discover 3,000 documents each, but usually the case comes down to these 5 documents. You know, those are the 5 ones, and the other 2,995 really have no bearing at all on the case. So the courts are so keen now to limit the parties' legal expense that they actually say, you go and work out what are the key themes in this dispute, and then you should give discovery in relation to those documents. And that's the sort of strategy that parties involved in litigation should be considering. If you can't get a deal done at an early mediation stage, then if you're going to go into the discovery phase, you should be really trying to limit costs by doing something like that.
Let's look at a recent example, the dispute between Clive Palmer and Premier Mark McGowan.
Yeah.
There was a hearing in Sydney a couple of weeks ago, and the discovery in that process went as far as personal text messages from the Premier to Kerry Stokes and to his Attorney General, John Quigley.
Yeah.
Now, obviously not a typical dispute, but is there the danger there that if people go down this path, they might end up with their personal text messages?
Totally. Yeah, that's very true. And those documents were definitely discoverable because they showed what the Premier was thinking about the legislation that was going to have an adverse impact on Mr. Palmer. And also it showed what the attorney was thinking about trying to defeat that legislation, which was part of the claimed loss. See, discovery is so broad. The saying in the rules is any document which relates to any matter in issue in the party's possession, so whether they actually have possession of it, custody or control. So it might be your accountant has the document, but that you've still got to discover it because you can access the document. And so the ambit's so broad, and that obviously wasn't a great outcome for the attorney and arguably the Premier as well for those documents to come out. But they certainly were discoverable, and they become fodder for Mr. Palmer's QC in the court to cross-examine the attorney and the Premier on. So that's what happens with discovery, and I guess the advice there is try and limit things you put in writing, or if you're going to put things in writing, ensure that a lawyer's included, because then you can claim privilege over it and then it doesn't become discovered. So those are just things to bear in mind.
Okay, righto. So the fourth topic we're going to discuss is Office of Settlement. So do you want to run through that one?
Yeah. Well, I'll just say about Offers of Settlement, I mean, there's an art form to them, and the cases say that you need to tick certain boxes. One of the main advantages of making an offer of settlement, which parties invariably do in every legal proceeding, is that when you lose a case or when you win a case, you get awarded costs on what's known as a party basis, which means that of the 100 cents in the dollar that you spent, you probably might recover 60 cents in the dollar. So there's always going to be a loss. You're always going to lose money on that order. But when you make a good offer of settlement and you can show to a court after a hearing's happened that the other party was unreasonable not to have accepted it, then the court will consider giving you what's known as indemnity costs, which is 100 cents in the dollar. So there's that strategic advantage, and it actually psychologically applies pressure to the other side to settle a dispute. So those are the sorts of things to bear in mind. But in order to do it, you should always make them, as soon as possible, keep them open for 28 days, set out the reasons why you're going to win or why they're going to lose. Make sure that it brings if there's a legal proceeding on foot, make sure it brings it to a conclusion. There was a recent case involved about making offers of settlement in defamation proceedings, and that's a nuanced area of offers of settlement, because you've usually got to offer some sort of apology as well, which is going to sort of be able to be published by the person that's been defamed. So there's lots to it, but it needs to be genuine and bona fide and good faith, with usually offering an outcome which you think is better for the other side than they would otherwise achieve by taking it to court.
Okay.
And just from experience, some of the things, when parties are involved in disputes, we may be engaged on one dispute for them, there's a legal proceeding on foot, but the parties themselves have other issues between them, and they just want to bring the relationship they have to an end. And so when you come to the time of doing an offer of settlement and then the settlement deed, it's really important for the parties to keep in mind, well, are we going to bring to an end this commercial relationship in its entirety, or is it going to continue? That's really important for the terms of the deed and the way the parties might approach the offers that are made. So whether that ultimately results in a settlement occurring through a deed of settlement being executed between the parties through simply court orders. It's just something for the parties to keep in mind, depending on how they want that relationship to continue.
The other thing to bear in mind is if the key themes or the highlights, if you to take one thing out of these presentations, is always try to seek to resolve a matter as soon as possible and a dispute arises prior to commencing a proceeding. I always consider that to be in the party's best interests. And it's easier said than done. I think you need to engage a lawyer that's on board with that rather than just going down to court and getting enveloped in that hamster on the wheel analogy that I was giving a moment ago. Might let you take that.
Yeah, so once a proceeding has commenced if a without prejudice settlement conference hasn't resolved the matter, really pushing your lawyer to say, well, is this now right for mediation? Or are we ready to go to mediation? And if you do require documents, as we were saying earlier, tell your lawyer that so they can ask for them and set it in context so that the parties do get to mediation sooner rather than later is the hope. And seeking to confine discovery to the extent possible is an absolute requirement, whether that be for cost reasons, as we were saying earlier, or as you were saying, Mark, in terms of there can be some quite damaging material in discovery if parties let it be there. So trying to just really constrict it to what's absolutely required, as Aaron was saying. Typically most matters come down to 3 to 5 documents. It's not everything in the sun that really matters. And when you're making offers of settlement, just contextualise what are we settling here and how are we settling it, and are we happy with that?
Okay. That's been great. I really appreciated the time, gentlemen.
Pleasure.
And I think we've covered through that topic pretty well. Give Pragma a call at their office,
Yeah, sure.
or get in touch with Aaron or Nick. So thank you very much.
Thanks,
and
Cheers, mate.
thank you for listening.